A classic example of where you'll see a Form 14B motion used is if you're the applicant and under the rules, if you're starting an application, the respondent needs to be personally served with the documents. Somebody has to physically hand the respondent those papers. And the respondent is avoiding service. They don't want to get served. They're ducking out. They never answer their door. They lie about where they're living. They don't do anything else. Or let's say you've been separated for a couple of years. You may have even totally lost contact with the respondent. You have no idea where the respondent is living. Hopefully, even if they're still in Ontario, you try to find where they are and you just can't do it. So under the rules, it says that you need to serve the respondent personally with those documents or an alternative to personal service. And what you can do is you can bring a Form 14B motion. You can say in your notice of motion, hey, judge, I'm the applicant. I need to serve the respondent. The rules say I have to have the respondent served personally. In my affidavit, I've set out everything I've done to try to serve the respondent personally and all the efforts I've made to find him, her, they, or whatever. And I've been totally unsuccessful. But I know that they're on Facebook. They've got a social media page. They're still posting on it all the time. So I know that if it was posted on their social media page, it would come to their attention. Or they've got an email address and it's a valid email address. And I know because they emailed me from that address just 2 months ago to thumb their nose at me or whatever. But I know if I was given an order that lets me serve them by email, that if you give me an order that says I can start the process by serving them by email, then I can get my application going because I simply can't do what I'm supposed to do, which is to do personal service. So that's a really, really common usage of the Form 14B. Moving party is the applicant. They just do the paperwork, gets filed with the court. The judge reads it all. If the judge is satisfied that you've really exhausted all your efforts to try to do personal service and you just can't do it, then the judge will make an order for substituted service by saying, okay, you can serve the person by doing something else other than having to have somebody physically hand them the papers because you've established you've tried and you just can't do it. So that's one of the most common ones. Another thing that'll happen is in family law, again, when you get served with an application or a motion to change, you have 30 days in which to file your answer. Sometimes you're gathering documentation, you might not have your income tax returns done or anything else, and you're just not going to be able to file any of the documents or all of your documents within the 30 days. You can bring a Form 14B motion asking for an extension of time to file your documents. So again, it's a procedural one. And there's an example of one that can go a number of different ways. Like, let's say you're the applicant, Heather, and I'm the respondent. You've served me with an application. I've tried to get an appointment with my lawyer, but there's no way I'm going to get to see the lawyer within the month after I've been served with the documents and have the lawyer prepare all my documents. But my lawyer is going to prepare my documents for me. But the lawyer's already said, we're not going to get this done in the 30 days after you've been served. So I pick up the phone and I call you and I say, hey, guess what? Yes, I've been served. I plan to file responding material, but I've just met with my lawyer. We're going to need an extension of time to file the answer. Will you consent to late filing? You could be a really, really nice person and say, sure, no problem. I'll agree to that extension. And then when you go to your first appearance, you could just do it in front of the clerk where you acknowledge that you're consenting to an extension of time for me to file my materials. Or I could do, or have my lawyer do a Form 14B motion with a consent signed by you saying all the parties are agreeing that the respondent should have an extension of time for serving and filing materials. So that can go by a Form 14B. The issue is even if you consent to the extension of time, but there's not a notation either because a court clerk does that on the first appearance, or if there isn't a Form 14B motion and an endorsement that there's a consent to late filing. If I'm past my 30 days and I just try to file it without having anything filed with the court to show there's a consent to late filing, the court won't accept it. So you do need the other party's consent. A good way of doing that, as I said, is by having a Form 14B done. Sometimes the respondent might have their answer done, but let's say they haven't filed their income tax returns for a couple of years and there's a claim for support and they got to get caught up by filing their income tax returns. Under the family law rules, if you have to do a financial statement, you're required to attach to that your last 3 years of income tax returns and notices of assessment. You might have your answer, but you don't have your tax returns done, you're filing them all at once for a couple of years, and it's going to take Revenue Canada some time to put to process your income tax returns and your notices of assessment. You can do a Form 14B motion asking for an extension of time or allowing you to file your financial statement with your answer without the income tax returns and notices of assessment that the rules say you have to do it. So again, you're asking for an exemption from the application of the normal rule, and the other side may agree to it. They may not agree to it, but a judge will read it and say, no, this makes sense. Let's get filed what we can. Let's get moving on this. But then, okay, the responding party, when you do get your tax returns and notice of assessment, you have to get them and serve them on the other party as soon as possible. So again, you're just trying to keep the court case moving and getting things done. Oh, what else have we got? Okay, okay, let's go to the complete opposite, where you're the applicant and you've served me with your documents and I got them. A process server went out and served all the documents and you're counting on the calendar and the 30 days has gone by and you're hearing crickets. The other party is totally ignoring you. They haven't filed any responding material. They haven't tried to get in touch with you. They haven't asked for an extension of time to file or anything else. Again, so now you're dealing with an uncontested application because the other party has not filed an answer or a response. You can bring a Form 14B motion, which is a motion to the court, but this is one you would do on notice to the other side that has never filed their responding material, saying, hey, I started this application, the other party was served, the 30 days for them to respond has gone by, they have not filed any material, they're not cooperating, they're not communicating with me at all. Can I please have this matter set down for an uncontested hearing? Because the other side hasn't filed an answer. And you do that by a Form 14B. So you say, can you please give me a date for an uncontested trial because the other party has not filed any responding documents?
But
you're raising your hand.
Yeah, but in this instance, you do have to give notice, right, to the respondent, the responding party. Because I think that's what you said.
Technically, under the rules, you actually don't, because if the other party has not adjourned to the jurisdiction by filing responding material, they're deemed to have admitted everything that's being asked for in the application, and they're not entitled to any notice to any future steps in the proceedings.
Okay,
is literally what the rules say. But as a matter of practice, what the courts have done, they're saying that, look, this really, really isn't fair. If you're going to go ahead and do this, you really should give the other side a heads up to make them realize the seriousness of not responding.
Right.
Because what used to happen is that lawyers acting for parties would just go ahead, they'd let the 30 days go by, they'd do the Form 14B motion for an uncontested hearing, and they'd get an order at the uncontested hearing, and then the other party will come charging into court and say, oh my God, I had no idea, this is really important, or guess what, I really wasn't served. Like whoever says they served me with these papers lied. I had no idea this was happening. That's why I didn't respond, and they'll get the whole thing set aside. So the court said, well, we're not going to waste everybody's time by doing this uncontested hearing and listening to what the applicant has to say and making an order just to have the other party come in and whine and cry. So it makes it a lot harder for them to do if the party can say, look, I gave them notice of what I was doing. I offered to consent to late filing. I served them with the copy of my 14B motion for an uncontested hearing, so they knew this was happening. They didn't respond to that at all. I did the uncontested hearing. They didn't show up at that either. So that's what you're doing, is trying to stack the odds in your favor for all the reasons why a judge should not overturn an order that was made when the other party wasn't participating. Okay?
Sounds good.
Make sense?
Right. Yep. All right.
Okay, now again, sometimes what the parties can do is that if there's a temporary issue that's coming in and it might be a ways off before you've got your next court appearance, again, and you need an order right now, like I said, for example, for a document to be produced by a bank and the bank won't do it without a court order, the parties can agree. And you do that, again, you just do a Form 14B motion, you do it on consent, you still serve the other party, confirming that they've already consented, the consent is attached. Then all of that stuff goes before a judge and the judge says, yep, okay, this is what they need. They're all agreed what has to be done. You do a draft order that goes with it, and then you make the judge's life real easy. You even set it so that their endorsement just has to say order to go in accordance with the draft order file. And then the draft order that you filed gets turned around and made into an official court order, like really, really quick. We'll
Right.
talk about that later on if you wanted to, because you were really interested about the difference between what's an endorsement and what's an order, but we can talk about that later if we have to too.
Right.
Okay, now sometimes what'll happen is you might end up in a proceeding where the family law rules are really clear about what the process is when you're going through a family court proceeding. You start with an application, the other party files an answer. They've got 30 days to do that. Then the parties have their first appearance before the clerk. And at that time, the clerk confirms everybody's done all the documents and filed them that they have to do, or if there's any consents or extensions for late filing, then that happens. Then the next step in the process is a case conference. And then after the case conference, if they can't settle at the case conference, the next step is a settlement conference. And so it goes. So every step of the way, you're working your way towards trial by like going over all of the hurdles that are on the way. And at every step of the way, the court is trying to see if they can get you to settle. Okay, but sometimes somebody throws a monkey wrench into the works, because you might have somebody that before they even have the first case conference, they go ahead and they file an urgent motion saying this can't wait, because normally if you're asking for substantive relief, like one of the claims you've made in your application, you can't ask the court to make a substantive order unless it's on consent and you're doing it by Form 14B without having had your case conference first. So let's say somebody brings an urgent motion before the first case conference because there's an urgent situation that does meet the test for what urgency is, and people can watch your video to see how that works. And then once that urgent order is made, then it's saying, okay, what do we do now? Because the order that we were going to be talking about at the case conference, we had it made on this emergency motion. So do we actually have to do a case conference, or can we move ahead to the next step, which is a settlement conference, or what should we do next? So sometimes if you hit a point in the process and you're not sure what you need to do, then either A, the other side agrees, yeah, we need a judge's direction to do this, and you do a Form 14B motion on consent asking for direction, saying this is what we've done so far, this is where we're at, what is the next step we need to take in this process? Now, always when you do that, though, make sure that you've read the rules, because if a judge is asking you something you can find the answer to in the rules, the judge is not going to be very happy. But sometimes, like I said, procedures take little side trips and everything else in the way they go. Then you can use the Form 14B to ask a judge to say, hey, we're not sure what our next step should be at this point. Can you tell us what we should be doing next? And the judge can give directions on what the next steps are. So those are usually the most common things you're going to see a Form 14B used for. And again, as I said, now to flip it around, I said normally, if you're asking for an order for substantive relief, like one of the things that you've made a claim for in your application, you cannot do that unless you're in an emergency or urgent situation until after you've had your first case conference. The Form 14B motion, you don't have to wait for your first case conference. Because you're not asking for substantive relief. Generally, it's either you're agreeing to something that needs to be done, or you're asking for directions, or you need to get an order like for substituted service or something like that. So you do not have to wait till that first case conference before you can do a Form 14B motion. So that's pretty much what a general motion is, and then what a Form 14B motion is and when you would use it. And then the last part of the video is just talking about how to bring a Form 14B motion.